Each party will have up to 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I'll be keeping track of the time. And the arguments are being recorded, so please stay behind the podium, keep your voices up, introduce yourselves. You should not use the names of children or minors or victims should that be relevant to your argument. You can refer to those folks by initials or by generic terms. And the judges have read your briefs and are ready to proceed when you are, and I would just ask the appellant, would you like to reserve time?
Yes, Your Honor. I'll reserve 5 minutes for rebuttal.
Very well, then you may start when you are ready.
Okay. Good morning. My name is Scott Friedman. I'm here on behalf of the appellant, Michael DiPalma. As I'm sure the court is aware, this case involves a joint account held by the defendant, appellee Catherine DiPalma, and her father, John DiPalma. The facts here are mostly not in dispute. Specifically, John DiPalma contributed all the funds to that joint account. Prior to John's death, Catherine withdrew pretty much all that was left, approximately $85,000 from those accounts. The state Supreme Court has established an ownership during lifetime presumption. That's in Thompson, Bloom, and Cowley. And under that presumption, even if it's a joint account with the right of survivorship, a party essentially owns what they contribute to that account. In other words, if I own a joint account with the right of survivorship with another person and I contribute all the funds to that account, this presumption says the money in that account is mine. Even if the other person has access to those funds, even if they can withdraw those funds, it still remains my money, unless there's clear and convincing evidence of a different intent.
Counsel, can I ask you,
Yes.
Were there stipulations at the trial court level regarding terms and conditions that John and, the Fifth Third Bank account terms and conditions that were signed by John and Catherine, saying that either joint customer could withdraw all or a portion of the account balance? Was that stipulated too?
There was no dispute as to the contents of that account agreement.
Okay.
If that's what you're asking.
Was there a stipulation that John understood that as joint owner of the accounts, Catherine could withdraw funds at any time from the accounts?
That was in the agreement, and as far as I know, that was John's understanding.
Okay, and was there a stipulation at the trial court level that at no time during his life did John object or complain to Catherine or Fifth Third regarding Catherine's withdrawals from the accounts?
As far as we're aware, that's true.
Okay, thank you.
Now, it's also important to point out, we're not sure if John was aware of these withdrawals. Catherine's deposition testimony says John, at the point of her withdrawal, was, in her words, a dying man. He was on his deathbed. That was her understanding. I don't know if that's true. I don't know if there's medical testimony to support that. Well, there isn't medical.
Let me just interrupt for a second. My understanding is this was all, summary judgment was rendered by agreement of the parties based on stipulations of fact.
That's true, Your Honor. Most of the facts
So
here really are not.
So some of this that you're talking about, like deposition testimony and so forth, that went even in before the court, right?
That's in the record. I believe that the depositions were filed with the court.
Okay, but what I'm asking you, I guess, is if you had agreed stipulations and you agreed that the
Yes.
trial court could render a decision based on those agreed stipulations, the trial court shouldn't have been looking at anything else, right?
Well, it was based on the stipulations. I don't dispute that, Your Honor. But what was not in dispute was John contributed all the funds to that account. And under this ownership during lifetime presumption, the money that Catherine withdrew, that $85,000, did not belong to her. Now, because they were not in a joint survivorship account any longer, and those funds did belong to John DiPalma, it's our contention that Catherine DiPalma does not have a survivorship right by virtue of the fact that they're no longer in a survivorship account. She doesn't get the benefit of that account if the funds aren't there.
The trial court seemed to be minded to the decision, took the view that that argument was to be made by Mr. DiPalma during his lifetime and not the estate after, because at that point the fund would have gone to Mr. DiPalma or the daughter, whatever her name happened to be, would have gone to her anyway. So in this particular case, why did the trial court wrong about making that determination based on Thompson and Wright v. Bloom and the other case?
Because, Your Honor, the trial court follows a line of cases out of the 11th District. And as far as I know, the 9th District hasn't followed the same rule that essentially says that, as you mentioned, challenge to the transactions have to be made during the lifetime. Our I'm not aware of the Supreme Court of Ohio adopting this rule, or really any other districts other than the 11th. As far as I can tell, that's outlined in Stowers, Platt, and Maloney, again, all 11th district cases, nowhere in the 9th district, as far as I know. But that's really at odds with the ownership during lifetime presumption. The ownership during lifetime presumption says that that money did not belong to her.
Well, that money's in there, she has the right to take it pursuant to the terms of the account.
Correct.
And did Mr. DiPalma give any claims that, or make any comments, he didn't want her to take any of the funds from there?
Not as far as we know.
There's no stipulation regarding any limitation on her ability to take that account that existed pursuant to, fund that account that existed pursuant to law, is that correct?
No, she had access to those funds. She could, if she so chose, would empty the account, as she did. That doesn't change the ownership of the funds in that account, though. And again, her only right to this fund was one, to access the account, but she only got a survivorship right because it's in a survivorship account. She wants the benefit of that survivorship account, even though the funds are no longer in that account. So the fact remains, the reason I do have one of the reasons I have a problem with this 11th district rule is that it essentially excuses somebody for taking funds that don't belong to them, that are no longer in a survivorship.
They do belong to them. The question becomes, if there's a dispute between Mr. DiPalma and his daughter, then it's a question of who contributed those funds. Otherwise, the funds legally belong to her at that point in time. She has access to them, she can take them. No one can say she cannot. You're saying they're not hers. Because I would read the case law, it's clear they're not hers. It just gives the right to Mr. DiPalma to say, wait a minute, you took all this money, that's not what I wanted.
Well, I don't agree with that entirely, Your Honor. She did have access to those funds. She could withdraw the funds, but that doesn't mean she owns the funds. If the funds stayed in that account and John passed away, then we wouldn't be arguing here today. There'd really be no issue to argue. The funds would be hers because they're in a survivorship account. She has a right to survivorship. Under the ownership during lifetime presumption, there's a presumption that that money is not hers. Even if she has access to it, even if she can withdraw it, it still doesn't belong to her. So what's her ownership interest to the extent there is any? She has a survivorship interest, provided they remain in a survivorship account. If they're not in a survivorship account, she's not entitled to a survivorship benefit.
And it seems like it's pretty clear, as the court found, that it was the decedent's, plan to have her receive these funds upon his death.
Well, that may be, Your Honor, after his death. That doesn't entitle her to ownership of the funds outside of that account. So I understand.
But there is case law that says that you should try to effectuate the intent, if at all possible.
Well, that's true, Your Honor, and I'm not aware of any evidence that would support the idea that John intended her to keep all those funds prior to his death.
What about the agreement itself, though? Catherine withdrew the funds from the account, which you say is okay, right, under the agreement?
Well, she's allowed to under the agreement.
Okay, she's allowed to withdraw the funds under the terms of the account agreement, and at that point, wasn't it then deemed ratified and approved by John? Would you agree on
Under the terms of-
agreement?
Yes, sir, under the terms of that agreement, yes, but that doesn't change the ownership.
I hear what you're saying. I'm just trying to understand that hair that you are splitting with respect to, she can withdraw it, and then what could she do with it if it's not hers?
Well, prior to this withdrawal, this was for the purpose of her assisting John in his day-to-day activities. So if we're talking about the intent of the parties, the intents, just based on the facts, seem to be her assisting John with his day-to-day activities, and then after the death, then it becomes hers. It
Are there
wasn't the intent
stipulations
for her.
as to what the use of this fund in those accounts were in this case?
I'm sorry, yeah?
Are there stipulations in the record about what the money in this account was supposed to be used for?
I don't recall specific stipulation as to how the funds were to be used.
That seemed to me to be a big distinction. If there was a stipulation that's supposed to be used for A, B, and C, fair enough. If there's no
Right.
stipulation, then there's no stipulation of what to be used for.
Yes, and
And you just made the statement they're supposed to be used for him. Did that stipulate you in the record?
I don't know if that was the stipulations that formed the basis of the summary judgment, Your Honor. I know that was in the record, but in any event, I do understand, at least initially, looking at this case, the temptation to believe that, hey, she was gonna get the money anyway, John was gonna die, you know, why not give her the right of survivorship? But the fact remains that there are protections in place, and I think that's the purpose of this ownership during lifetime presumption, to protect people that have these joint accounts with family members, with people they trust. Catherine did have a right of survivorship, but the only reason she had that right is because it was in a survivorship account. The money wasn't hers, there's no question that the money all came from John. She had the right to withdraw the funds, but that doesn't change the ownership nature of those funds. Because they were not in a survivorship account, she should not be entitled to the rights of survivorship. The trial court and Catherine, their positions seem to be based, primarily on these 11th district cases, but specifically a rule announced under Stowers. And in Stowers, the wording in that court was
And
in
counsel,
the
I should let
context.
you know that you moved into your rebuttal time.
Okay, I appreciate that. If there are any, unless there's any further questions, I'll reserve the remainder of my time for rebuttal.
Thank you.
Thank you, Your Honors. May it please the court, my name is George Polis, along with attorney Mark Wiseman. We represent Catherine DiPalma, the appellee in this matter. Good morning. I respectfully request on behalf of Catherine that this court affirm the ruling of the lower court and determine that Catherine is the rightful owner of the funds in dispute in this matter. I'd like to first directly address the arguments made by Michael's counsel in this matter. Specifically, counsel's assignments of error and arguments disregard the totality of the case law and the stipulated facts. I would encourage, if the court has not done so already, to review the full list of stipulations which are completely articulated without omission in Catherine's brief in this matter. Specifically, per the deposition stipulation number 9, John DiPalma understood that as a joint account holder and owner in joint and survivor ownership of the account, Catherine DiPalma could withdraw funds at any time from the account. That's stipulated. Both parties moved for summary judgment. Both parties asserted that there were no material facts at issue. Both parties negotiated these stipulated facts and presented them before the court. Michael agrees that John knew and understood that as joint account owner, and that Catherine could withdraw funds at any time from the accounts. Both parties did stipulate to the Fifth Third Bank account terms and conditions in this matter. Both parties stipulate that John understood that according to those terms of the depositor rules and regulations, upon his death, the joint owner and survivor automatically becomes the sole account holder. Additionally, counsel ignores the totality of the case law. Specifically, Wright versus Bloom limited the Thompson case that's cited by restricting the Thompson decision to controversies arising during the lifetime of the parties. Those parties being John DiPalma and Catherine DiPalma, the two joint account holders. There was no controversy, and that fact was stipulated. Additionally, there was no argument, another stipulation, there was no argument as to duress, undue influence, lack of capacity, impairment, or coercion. At all time, at any time relevant to this matter. That was not considered by the court because the parties stipulated there was no duress or undue influence. There was no argument to lack of capacity. John DiPalma never challenged the withdrawal by Catherine, and the trial court points out to the evidence that there's no issues of capacity. There was no challenge to the withdrawal, thus there was no controversy during the life, and thus Catherine should be entitled to the funds.
Is there any stipulation that John was aware of the funds being transferred?
There's no stipulation and no evidence.
Counsel, the other question I was thinking is, I understand that, case law, not necessarily from our district, and depending on how you interpret it from the Supreme Court, that you obviously survivor between the two people as to whether they're objecting to the monies that are removed from the account and used. I guess what I'm wondering though is, under these circumstances, or under any as far as that goes, doesn't the estate have a competing interest to make sure that all funds are incorporated into the estate? And who has the more appropriate interest here, I guess is what I'm saying.
Sure, and that goes directly to the issue of dispositive objective, and that was discussed in the Wright case, that these joint accounts with rights of survivorship are considered dispositive objectives. This is the intent of the testator to be used as an estate planning tool. So I would say that in the case here in particular, and in the other cases cited by counsel, you have, it's why the depositors and the joint account holders have to have a controversy in life, because it is that decedent's dispositive objective that's at issue. And you do often have in other cases competition. I mean, competition between a dispositive objective and a will, just like this case, and the testator's dispositive objective with joint accounts. The bottom line is that that's why there has to be a controversy in life. It was the testator's wish that Michael have the assets of the estate, and it was the testator's objective to have Catherine as the joint account holder and abide by the terms of the agreement, which was stipulated to. These facts are case determinative, and like in this case, it does follow the Stowers case. In that case, very similar. A daughter was a joint survivor account holder and withdrew funds, and there was an objection only after the death. There was no objection or challenge to the withdrawals that occurred during life. And in that case, furthermore, there were no allegations of undue influence or lack of capacity. And so the court held exactly that. Because there was no challenge during the life, because there were no allegations of undue influence, fraud, lack of capacity, or impairment, that the funds were were determined to be the assets of the daughter who withdrew them from the joint survivor account. Okay. I would say that the three tenets of this case and the law go back to the controversy must originate during the life of the two parties to the account. Again, second tenet, the probate court safeguards the wishes of the decedent and those dispositive objectives. The trial court found that as well. Wright versus Bloom established that the law of the land, that joint accounts were dispositive objectives, and that should hold true in this case, to carry out the intentions of the decedent. In tenet number 3, the facts of this case are confined to the stipulated facts. Stipulation as to the joint survivorship nature of the account, that the rules and regulations were always followed in the account, that the decedent knowingly, willingly, purposely added Catherine as a joint owner on the account, that he knew the rules and regulations by adding her as a joint account holder, that she could withdraw funds at any time from the account, and the stipulation that John did not object or complain to Fifth Third Bank or Catherine regarding the withdrawals of the account.
And counsel, maybe you answered this, I'm not sure, but so was there evidence that John knew Catherine was taking the money out of the joint account?
There was no testimony one way or the other, and no stipulation.
Okay, so there, beyond the stipulations that, in the agreement, that for the account, there is no evidence that he gave Catherine permission to use the money for her own personal benefit?
That's not, no. The stipulations specifically say, the parties agreed that at no time during his life did John object or complain to Catherine or Fifth Third Bank regarding the withdrawals. And the parties also stipulated that John knew at the time that he signed the account agreement that according to the rules, she had authority to withdraw funds at any time from the account. So the parties did stipulate to those facts.
Thank you, counsel.
Do you agree with Alan's statement that during the lifetime of Mr. DiPalma, the fund belonged to or owned by Mr. DiPalma, even though they were in a joint account based upon right first blood?
No, I don't agree. If that were the case, then every husband and wife, brother and sister on a joint account would be guilty of violating a law or stealing from their sibling or their parent every time they used an account, or even their spouse. And that's why, going back to the approach in the courts, controversies in life, we all have joint accounts, or many of us have joint accounts. Absent a controversy in life, there is not an issue or a violation with the usage of the funds. Plainly speaking, I was talking about this case with my wife last night, and I said, if our side is wrong, every time I transfer funds to pay bills from our joint account, I've been a violator of these rules when I pay our house bills from our joint accounts. There's no controversy in life, and therefore there's no challenge to the withdrawals, and therefore the funds should belong to Catherine.
I was gonna say, thankfully, there are more protections between husband and wife, so different laws that apply, but thank you.
Your Honors, if there's any further questions, I'd be happy to answer them.
Thank you, counsel. Hearing none.
Thank you.
Mr. Friedman, you will have 4 minutes and 39 seconds for rebuttal.
Thank you. I do want to first address this comparison between a joint account between husband and wife, because I don't think there really is any valid comparison.
Well, there'd be issues to deal with that under 31 of the code for divorce and everything else, so I don't think it's an issue for these folks.
Right.
Don't know that
Family
it
law.
works completely, but the law for joint accounts is what it is.
Right, and family law is a little bit outside of my wheelhouse, but the comparison, I think, is with all due respect, to just not a valid one. In this case, they weren't living, John and Kathleen weren't living together, they weren't, sharing expenses. And I also have to emphasize that her, in our opinion, she forfeited her survivorship right because of her own conduct. She didn't have to withdraw this $85,000 from this account and put it in her own account. She could have waited, and then she'd done that. She would have gotten survivorship rights. I have no dispute about that. Had she done nothing, had she waited, then the money could have been hers, assuming John wouldn't have done anything differently. But the fact is, if we're talking about the intent, there's no evidence to suggest that John intended her to take this money for herself prior to his death. The
But there is evidence that John wanted her to inherit it and not go to his estate.
after his death, Your Honor, yes.
Clear, that's what his intent was. If we're trying to figure out what his intent was, he wanted Catherine to have his money, as far as anything we know at this point in time.
Yes, Your Honor. After he died, it was his intent that she get the money after he's deceased. But
there is evidence, right? Because John signed the agreement, the bank agreement, that says that any joint customer may stop payment, close the account, withdraw all or a portion of the account balance, and that was one of the things that was stipulated to.
And I don't dispute that, Your Honor, but that doesn't give Catherine ownership rights of that money prior to John's death. And I disagree with opposing counsel that the idea that this money is owned by John has support in the state of Cowling, as well as.
But the other
Sixth Circuit.
stipulation, wasn't there also evidence that number 9 on the list of stipulations, John understood that as a joint owner of the accounts, Catherine could withdraw funds at any time from the accounts?
I don't dispute that, Your Honor, but again, that doesn't.
But she wouldn't own it after she withdrew it?
Correct.
Okay.
So there's a difference between accessing the funds and owning the funds. Just by analogy, my neighbor gives me the keys to his
I
house.
understand.
I don't own the contents of his house, even though I have access to them. And the idea that John owns these funds, he doesn't forfeit ownership just because he puts them in a joint account. There's support in the state of versus Cowling, the state of Mayor, which is out of the Sixth Circuit. So, this isn't without precedent, this idea that the person owns the funds they contribute. And I think that's a very logical rule, precisely because it protects people that might, for example, in John's case, be elderly, need assistance, and open a joint account with a family member. That doesn't turn that into Catherine's personal piggy bank. And again, I think it may be it may seem as though I'm advocating for a pretty strict adherence to this rule that you only get the survivorship benefit if it's in the survivorship account, but I do think that is necessary to protect people in John's precise position. Again, Catherine put herself in this position. Had she done nothing, then the money very well may have been hers, but she doesn't get the benefit of a survivorship right if the money's not in that survivorship account. If she withdraws that $85,000 and puts it in her personal account before John dies, then she doesn't get the benefit. She's not entitled to it. The money's not hers. The Supreme Court's ownership during lifetime presumption says she took money that didn't belong to her, and therefore she's not entitled to survivorship rights. And there's no further questions, and I have no further argument.
Thank you very much,
Thanks.
counsel. Thank you both for your good presentations. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and will also